So we'll move on to discussing certain other aspects of the Constitution of India, which, in one sense, lays down certain aspects of public administration, and will also tell us how the Constitution lays down what we know as the public policy in public administration, because there are certain parts that are relevant and important for us to understand how the public policy dimension has been designed, structured, and has evolved over a period of time. So, let's start with the amendment to the Constitution of India. Uh, as we all know, friends, the Indian Constitution is a written constitution, and hence it does provide for amendments. Now, amendments are kind of a process in which the Constitution is changed over a period of time. Now, we know that there is a very interesting juristic saying that the Constitution must reflect the aspirations of every generation. So, our forefathers who gave us this constitution had a particular type of thought. They had a process. They had their own ideals. They had their own aspirations at that given point of time. And the current generation may have its own aspirations, and hence the constitution ought to be. I would not put it in this sense that it should be flexible, but it ought to, resonate with the aspirations of the current generation, and hence we have to say that the constitution must be a reflection of the public society or the public policy of current times. So generation to generation may determine what should be the public policy in the constitution, and hence we would say that the Indian constitution is a kind of a mix between what is the constitution in Britain, because in Britain the constitutional change is very easy as compared to the United States, where it is very rigid. So you can't, the rigidity of the American Constitution is very well known. It's not easy to change the American Constitution, whereas it is quite easy to change the British Constitution. So India adopted a kind of a middle path, and we have created a kind of a synthesis between rigidity as well as flexibility. So we have certain part of the constitution that is very rigid, which should not be touched or amended. That is precisely what basic structure theory laid down. And certain parts of the constitution which ought to be flexible, and they are allowed to be changed from time to time. Uh, as we all know, friends, the Indian Constitution is probably one of the largest written constitutions of the world, and hence there are so many parts in the Constitution that can be changed without touching the basic fabric of the Indian society or touching the basic fabric of the Indian public policy. So, Article 368, this is Part 20 of the Constitution, deals with the power of the Parliament of India to amend the Constitution, and it also lays down the procedure in which such amendment can be done. So, in the exercise of the constituent power, uh, the Constitution, through an amendment, can do an addition, it can do a variation, or it can repeal any provision of the Constitution in accordance with the procedure laid down for that particular purpose. However, as we all know, friends, this kind of an amendment to the Constitution is not a blanket power, it's not an absolute power, it is not a power that can amend the entire Constitution or replace every part of the Constitution. That, unfortunately, is not present as the power to amend the Constitution. So, the Parliament does not have an absolute power to change the Constitution or amend the Constitution, as the case is. And I think the Kesavananda Bharati case of 1973 is a very landmark judgment that actually uh, kind of lays down the scope and ambit of Article 368. Now, the procedure for amending the Constitution is as follows. It is quite a elaborate procedure, but let me just tell you a few things about how the Constitution can be amended. So, an amendment to the Constitution can be initiated by introducing a bill in either of House of the Parliament. But please note, such kind of bill cannot be introduced in the state legislature. So it is only the central government or the federal government that has the power to change the constitution, and the state governments have not been given that kind of a power. Second, it can be introduced either by the government through its minister, or it can be introduced by a private member who is, a member of the parliament. He is not part of the government. And this does not, the introduction of this kind of an amendment bill does not require the prior permission of the president. Now, the bill must be passed in each house, that's the Lok Sabha and the Rajya Sabha, by a special majority sometimes, and sometimes by a simple majority, or sometimes by a special majority and ratification of half of the state legislature. We will try and understand which of the part of the constitution will require these three processes. And you will notice that sometimes it would require a two-thirds majority, as the case is. That is what special majority is. Simple majority is more than half, what is known as. So please note, such a kind of a bill to amend the constitution cannot be done through a joint sitting of both the houses. It shall be passed in each house separately. And in case there is a disagreement between both the houses, then interestingly, you will notice that in an ordinary bill, a joint session of both the houses can be called in. But for a constitutional bill, no such provision of holding a joint sitting of both the houses is provided for. Uh, so you will notice that there is a requirement that the president's assent is required, and you will notice that uh, the president must give his assent or her assent, and in case the president withholds his or her assent, then the bill cannot be sent back to the president once again. So the constitution would stand amended once the president gives such an amendment. So the role of both the houses and the president is critical in bringing about any such constitutional amendment. So, if you look at it, there are three ways in which the amendment process in the Constitution can be brought about. Let's look at by a simple majority, right? A simple majority of both the houses. Uh, can it be done, right? So, for example, some of the provisions of the Constitution that may be amended through a simple majority can be, for example, establishment of a new state or admission into a new state. So formation and alteration of the boundaries of the state can also be done by a simple majority. Quorum in a parliament can also be decided. Salaries and allowance of the members of the parliament can also be decided by the simple majority rule. Privileges of the parliament and its members. Sometimes use of English language in the parliament was also passed through a simple majority. Conferment of more jurisdiction, not breaking down the jurisdiction of the Supreme Court, can also be done by the simple majority. Recognizing official languages was done through a simple majority. Citizenship sometimes can also be done. Union territories or defining union territories, fifth schedule, sixth schedule of the Constitution was also done through simple majority. Now, most of the other provisions of the Constitution require a special majority. And you will notice that a special majority means two-thirds of the members of each of the houses have to agree. And when we say, two-thirds of the total membership, it means that the total number of members comprising the house, irrespective of the fact that there were any vacancies or absentees. So it's not two-thirds of those who are present, two-thirds of the number of members in the house. So that is the special majority that is there. So absentees and vacancies cannot be looked into to decide two-thirds. So it is two-thirds of the total membership in each of the house. So that's very critical to bring in the rule of special majority. Now, special majority usually requires a voting, and please note it would require voting after the third reading of the bill in the parliament, and this has to be provided through the various procedures and rules of the house. And you will notice that where does this two-third majority apply? Please note, friends, it applies to fundamental rights. It could apply to the directive principle of state policy. and it provides to all other provisions which are not covered by the first and the third category. So usually two-thirds majority would be insisted upon, and that is something that is used to amend the constitution. Now, when is the special majority and the ratification of half of the state legislatures may be required? Because you know that there are constitutionally powers that are granted to the states, that are certain provisions in the constitution that determine center-state relationship, and hence, unless more than half of the state legislatures have given their consent, the formality of amending the constitution will not be completed. So, interestingly, you should notice that to get the ratification of half of the states, now we have 28 states, that means 14 states will have to agree to this kind of an amendment bill process of the constitution. There is no time limit that is fixed, so they may agree within 6 months or 6 years, but nevertheless, unless that kind of a consent is given, the amendment bill does not come into operation at all. So the following provisions would require not only a simple majority of the Lok Sabha, Rajya Sabha, and the assent of the president, it also requires the ratification of half of the state legislature. They are the following. First, election to the president and its manner. Now, this, if it has to change from the existing structure in the constitution, it would require simple majority and half of the state legislature's ratification. Extent of the executive power of the union or the state, any changes in that. Supreme Court and High Court changes. Distribution of legislative powers between the union and the state, especially in terms of the seventh schedule of the constitution. Something like the Goods and Service Tax Council that was established. So anything as per the seventh schedule will be covered over here. Representation of states in the parliament, especially in the Rajya Sabha, and the amendment process itself in Article 368, all of these would require the consent of at least half of the states. So that's how the amendment to the constitution can come into place, and you will notice that the amendment process under 368 has its own has its own advantages sometimes, and does not fit into the very role of what critics would want the amendment process to be. So what have critics said about the amendment process or procedure to the constitution? They have said that while India in its constitution has balance between rigidity and flexibility, sometimes it would be required that the joint sitting of both the houses of the parliament uh, need to be brought in, because this is the only way in which deadlocks on certain crucial aspects can actually be resolved. So it was important that the procedure for amendment could have had a joint sitting, because sometimes the party in majority is a party that is having majority only in the Lok Sabha, not in the Rajya Sabha. So it may disturb the public policy vision of the ruling party, because it requires that kind of a majority in both the houses independently. So why not allow for a joint sitting was one of the criticisms that was brought into place. Uh, Now, if one views Article 368, it is more or less, like a procedure that every legislation, sorry, in the parliament is enacted or brought into existence. So there is no special treatment to an amendment process. So should an amendment to the constitution be like an ordinary bill, or should it be something different? Should have been brought as a procedure. So I think that is some another criticism that people have levied to Article 368. And interestingly, while one has looked at the judicial review of the amendment to the constitution, one would come to this conclusion that Article 368 and the wordings in it have left an ample scope for the judiciary to intervene and test the constitutionality of every amendment, either on the procedural aspect or on the substantive aspect, as the case is. So, judicial review has often been a kind of a superseding power to Article 368, thereby, kind of giving legislative competence a kind of second door than the judicial wisdom. So, I think trying to balance or strike a balance between flexibility and rigidity. 368 does not give any kind of a special power to the legislature, or does not give exclusive power to the legislature to amend the constitution. As I told you, the legislature represents the will of the people. The legislature represents the aspirations of the society, because that is through direct voting or franchising that these people are brought to the parliament. So that's one thing of theory, of course, but that is something that has been said time and again. Finally, the criticism about the amendment procedure under 368 is that the states have no role to decide the framework of the constitution at all. So states cannot introduce any bill proposal to change the constitution on their own self, unless they are part of a coalition in the government, and they play a role regarding the same. So I think there is one benefit of the U.S. Constitution, because the United States is a union of states, and there are two constitutions there. So the states can also make a proposal to change the public policy dimension in their own state by bringing a change to the constitution. But that is not possible in India, because states don't have their own constitution. Neither can they contribute and participate in reflecting a constitution that is required as per public policy of the times. So that's one final criticism that some may have under the process and procedure of 368. Having said this, one will notice that a constitution is a very organic, dynamic, very vital document that decides the lives of people. It should be like a living and breathing document. Uh, it should be solid. It should be permanent. At the same time, it should result in showing the kind of flexibility that is required to draw the rights of people and the duties of the state, and hence there must be enough sense of accountability of the ruling party and the government of the day. There must be a sense of transparency in the decision making process. I think rule of law and not rule of men should be something that the constitution should be able to fulfill from time to time. So I think that should be good in terms of understanding what the amendment process is. Now let's move on to the basic structure theory, because as I told you, one of the aspects of the constitution is that the constitution is flexible. However, certain parts of the constitution are considered today, thanks to the Kesavananda Bharati case, to be very rigid. When I say rigid, it means they have been given a special status called they are called as the basic structure or the basic feature of the constitution, and these features cannot be changed. It cannot be amended at all, and the law has continued to stay the same, right? Now, if you go back to how the constitutionalism grew from the constitution, constitutionalism means the working of the constitution. How has the constitution worked over a period of time, all these years? And if you see that, uh, in one of the first cases that was decided in 1951, this case was called Shankari Prasad. Uh, the first constitutional amendment that was brought in 1951 was challenged. Shankari Prasad. Okay, that is the case. Um, I can give you the complete Shankari Prasad versus Union of India 1951. So in that case, you will notice that the first amendment to the Constitution curtailed right to property under Article 31 of the Constitution, and hence the first amendment to the Constitution itself was challenged. The Supreme Court at that point of time said that the power of the Parliament to amend the Constitution includes Chapter 3 or fundamental rights as well. Because uh, if you see in Article 13, there is a definition of law. Law includes what, right? And please note, law includes any ordinance, order, bylaw, rule, etc. So the word that was used in Article 13, they said includes only ordinary law and not constitutional amendments, right? And therefore, the parliament can abridge and take away any fundamental rights, okay, by enacting Constitutional Amendment Act, and as such, a law will not be void under Article 13. So, so they said constitutional amendment law is not ordinary law, and it is not covered under Article 13. So this constitutional law can abridge fundamental rights, but any other law cannot abridge fundamental rights, right? So if that is the case, then it can be challenged. So that is what we say: the procedure established by law, or any law cannot abridge any of your fundamental rights. And what is that law which cannot? It is defined under Article 13. It can include rules, regulations, ordinance, notifications, orders, and bylaws. They cannot abridge your fundamental rights. But can a constitutional amendment abridge it? In Shankari Prasad versus Union of India in 1951, the Supreme Court says yes, because that is not covered under Article 13. This is a higher law, and fundamental rights can be affected by the amendment to the Constitution. It can be abridged, and hence the court said, we will not intervene with the parliamentary power. So it meant that in 1951, just after independence and Constitution being adopted, the parliamentary supremacy was established by the court, and the court said the parliament and the legislature are supreme. They can change the constitution as they wish, and whichever part they wish. Right? So, amendment power was considered to be absolute. And in 1967, in a case called Golaknath, the Supreme Court kind of reversed its earlier stand. And in this case, the 17th Amendment, so please note from 1951 or 1950 till 1967, already 17 amendments to the Constitution were already brought into place. So please see the kind of mischief that was being used to amend the Constitution from time to time, and making it over flexible would have resulted in diluting the Constitution and the principles of the Constitution, or the fundamental law of the land, and treating Constitution like any other bill or act was happening during those days. Now, the Supreme Court in Golaknath in 1961 ruled that fundamental rights are given a very important position in the Constitution, and hence the Parliament cannot abridge or take away these fundamental rights. Okay. So they said the constitutional amendment is also included under Article 13 under the definition of law, and hence such a law can be held to be void by the Supreme Court in a judicial review, as the same law may decide to abridge the fundamental rights of citizens. So any law that is in violation of fundamental rights is void to the extent it's unconstitutional to that extent, and hence the Golaknath case of 1967 said that amending to the Constitution is a law that is covered under Article 13 of the Constitution of India. Now, unfortunately, once the Golaknath case came in 1967, the Parliament felt kind of insecure because they had enjoyed supremacy to decide about public policy in the Constitution, whatever is required. So the reaction of the Parliament was quite interesting. And the Parliament decided to bring in the 24th Amendment Act in 1971. Now, this Act amended Article 13 and Article 368. And it declared that the Parliament has the power to abridge or take away fundamental rights under Article 368. Okay, totally. And as such, the Act or the Constitutional Act will not be law under Article 13. So the Parliament reacted very strongly to the Golaknath case, and they superseded the Golaknath case by bringing a new amendment to the Constitution, which is called the 24th Amendment to the Constitution, and said we have all the powers, including taking away your fundamental rights, and you can't include this in article. So they neutralized whatever the Supreme Court decided in the Golaknath case. Now, in the Kesavananda Bharati case in 1973, this is a very important turning point. Whether Parliament is supreme or the Supreme Court is supreme was something that came about in the Kesavananda Bharati case. And of course, I think at that point of time, the Supreme Court had to lay down, kind of certain restrictions or limitations to parliamentary power. So what they did is that I think, a constitutional bench in the Kesavananda Bharati case, they said, and they kind of said that the Parliament is empowered to change fundamental rights. No problem. Okay. So it's not that the Parliament cannot touch fundamental rights at all. We will allow them to do so. However, it said that let us look at something called the basic structure. Now, you cannot allow parliamentary supremacy over the constitution at all times, because then this will result in kind of abuse of power. This will allow too much of discretion to the parliament. So they said, look, certain parts of the constitution should not be touched at all, and the parliament should have some kind of consciousness. So they must affirm their faith in the basic structure theory. They must say these are the parts that always shall continue to remain, and some of these parts can probably be changed. So the Kesavananda Bharati judges allowed the parliament to decide, but they said decide everything else except the basic structure, right? We'll also give you the power to decide fundamental rights if you wish, but then please don't touch the basic feature of the constitution. Now, please note, in 1975, in a case called the Indira Nehru Gandhi case, uh, this is Indira Gandhi versus Raj Narayan, the 1975 very famous case where Raj Narayan challenges the election of Indira Gandhi. So it's a very popular turning point in the Indian constitution. Uh, Raj Narayan said that Indira Gandhi had not won fairly in her elections. In that case, the Supreme Court invalidates an amendment to the constitution called 39th amendment to the constitution, uh, because in this 39th amendment to the constitution, uh, look what the parliament did. Because there was kind of a ruling party that had absolute majority in the house, and you had a prime minister who could not be challenged, or a leader who could not be challenged, Mrs. Indira Gandhi. What she did was she brought in a constitutional amendment to say that the election to the prime minister or the speaker of the Lok Sabha is outside the jurisdiction of the court itself. So, if there are any election disputes to the elections of the prime minister or the Lok Sabha, then the courts cannot intervene at all. So, a new provision in the constitution itself was added through what is known as the 39th Amendment Act. Now, the court here then had to step in, because the rule of law was completely dislodged here. Rule of law says everyone is equal before law. This is the basic feature of rule of law. Everyone is equal. Now, everyone means what? Despite or in spite of your status, however high you are in law, you are equal before the law, equal before the courts of law, equal before the justice provision of the law. Here, now the prime minister is putting herself and also adding the Lok Sabha speaker, just as a matter of courtesy, as being beyond the ordinary scrutiny or supervision of law. So at this point of time, I think the Supreme Court had to intervene. They had to step in, and they said say that this provision was beyond the amending powers of the Parliament. The Parliament could not, bring such a amendment, and this violated the basic structure of the Constitution. Now, I believe that in the Indira Gandhi versus Raj Narayan case, the court simply said that the basic structure of the Constitution is rule of law. Yes, rule of law is important. So, equality before law and equal protection of law is the basic feature of the Constitution. You cannot assume a role of being a superhuman and not being subject to the scrutiny and supervision of law. So, I think the basic structure feature of the Constitution was slowly kind of elaborated, explained, brought into existence thanks to the Indira Gandhi versus Raj Narayan case. The theory was laid down in the Kesavananda Bharati case, but it was expanded in later cases to say what basic structure of the Constitution actually meant. Again, please note, once the Indira Gandhi versus Raj Narayan case came in, uh, the Parliament had to react, because this was the times when the Supreme Court would say something, the Parliament would again say something. So in 1976, the Parliament passed the most major amendment to the Constitution called the 42nd Amendment to the Constitution. And this act amended Article 368 and declared that there is no limitation on the constituent powers of the Parliament, and no amendment can be questioned in any court of law on any ground, including those contravention of fundamental rights. So, one of the amendment features of the 42nd Amendment was to reiterate parliamentary supremacy on the amending powers, and reiterating the powers of 368 as being absolute power with the Parliament of India, and the Supreme Court or any court could not intervene on those grounds, was laid down. However, in the Supreme Court, in a case called the Minerva Mills case of 1980, they invalidated this provision in the 42nd Amendment, and the Supreme Court said that excluding judicial review is not something that is possible by the Constitution amendments. Judicial review is a basic feature of the Constitution. So the judiciary can question anything and everything, and that cannot be taken away at all, right? So they applied the basic structure theory in the Minerva Mills case and reiterated court supremacy to decide the constitutionality of any legislation or any constitution amendment bill, as the case may be. So in 1980, I think things slowly started settling down about who is supreme, whether Parliament or Supreme Court. I think it was very clear by this time that the Supreme Court was winning the battle in trying to protect the Constitution and the document of the Constitution, to protect rights in the Constitution, to protect citizens' interest in the Constitution, and also to lay down a new principle of constitutionalism, saying that judicial review and rule of law is the basic structure of the Constitution. So the court in the Minerva Mills case very clearly says that uh, amending power always is a limited power, and it must be exercised when only there is an absolute need of the same. They say that any power that is granted, please note, even in the amending power that is granted, if it is given to enlarge your own scope or ambit, then that would be a misuse of the power itself. And he said that even absolute power is given to the Parliament to do anything with the Constitution, please note this power would lead to kind of a destruction of the basic tenets of the Constitution. And I don't think political parties must be given the same, because political parties, unfortunately, are driven by a lot of ideologies and thoughts, and there is a lot of clamor to individual leaderships, and sometimes this tends to be abused by the political leadership. And hence, a limited power means maximum governance, a limited power means uncorrupt government. A limited power is very important to protect the rights of the people. So, government that has restrictions and limitations will also do good governance. So, a lot of development has happened on the basic feature. What else is basic feature? Okay, so I think with so many cases, one would say that the basic structure or the basic feature of the Constitution has been decided with the court of law, and they have added to what this basic structure actually means. So we have already decided that the basic structure of the Constitution means rule of law. The basic structure of the Constitution also means supremacy of the judicial review process, and that was very clearly that is laid down. So let's see what are the basic structure through various judgments and decisions. For example, I think uh, the the sovereignty of the country is a basic structure. Democracy is a basic structure. Republicanism is the nature of Indian polity. So we are a republic. We are not going to have someone as the king or the throne or the monarch ever in our nation. So that's a basic feature, right? So presidential form of government is not going to be a choice with the king in place. President is a position that is there in the constitution, and it has to be respected as it is. Free and fair elections is a basic structure. Federalism is a basic structure. Secularism is a basic structure. So federalism, secularism, democracy, unity and integrity of the nation, social justice, and judicial review. So six things were laid down in the most famous case called SR Bommai case of 1994. Sorry. So SR Bommai also was a very important turning point um, uh, uh, in our constitutional history. In another case called L. Chandrakumar, 1997, the power of the High Court and the Supreme Court under Article 226 and 32 was held as basic structure of the Constitution. Principles of equality have always been reiterated as basic structure. Freedom and dignity of individual has been accepted as the basic structure of the Constitution. Access to justice, right, is a basic structure. The welfare state is also a basic feature of the Constitution of India. Um, yeah, so I think through various decisions, uh, what is basic structure has been laid down from time to time. And I think one of the latest cases on basic structure that was pronounced was in 2014. It is called the Madras Bar Association um, versus Union of India, where judicial review and the power under 226 and 32 were reiterated by the courts. So I think it's now very clear that the basic structure theory is part of the Indian Constitution. It has emerged as one of the most important pillars of the constitutional democracy that has very clearly clarified how there ought to be a balance between the power of the parliament and judicial review. I think the judiciary is the custodian of the constitution. This very theory called the basic structure theory reiterates that, holds it to its firm position. And I think the judiciary has been able to kind of check and balance the power of the parliament and the legislature. That is precisely what checks and balances theory is. And through the basic structure theory, I think we kind of find out how the Indian constitution becomes a very robust public policy document, right? So I think whatever is the basic feature of the constitution is the public policy of this land, which cannot be compromised, which cannot be amended, which cannot be abused, which cannot be at any stage, result in abridging the fundamental rights of the citizens. So that is something that clearly comes out from the discussion on amending powers of the constitution.